The Supreme Court just dropped a legal bombshell. An emergency order that's about to flip second amendment law on its head across every state in America. For years, federal courts have treated gun rights like a second-class constitutional freedom, but that ends today. This new Supreme Court order could completely change how gun laws are enforced, how rights are protected, and how far states can go before the Constitution slaps back. Before we dive into what just happened, and why some legal experts are calling it the most significant procedural decision in decades, make sure you hit that subscribe button. Because what's unfolding right now will reshape every major gun rights battle across the country. Scales the double standard, finally exposed. Between 2022 and 2024, appellate courts blocked gun rights injunctions in 73% of cases. Let that sink in. When judges ruled a gun law unconstitutional, nearly 3 out of 4 times, those laws stayed in effect anyway. But when it came to free speech or privacy under the Fourth Amendment, courts only blocked injunctions about 30% of the time. So if a law violates your right to speak, it's stopped immediately. But if it violates your right to bear arms, it stays in force for years. The Supreme Court's new emergency order just told lower courts, no more double standards. Puzzle piece the 18-month loophole. Here's how states have been playing the system. They pass a restrictive gun law. They lose in district court, but instantly appeal. Then they request a stay, keeping the law alive while dragging out the case. That tactic lets them enforce unconstitutional laws for 18 to 24 months. On average, even after judges strike them down. During that time, people get denied permits, arrested, fined, and prosecuted under laws the courts already ruled unconstitutional. This Supreme Court order destroys that loophole, forcing appeals courts to actually justify why such laws should stay in effect during appeal. The 3-page problem. Some of these stay orders weren't even real legal decisions, they were rubber stamps. 2 or 3 pages long. No analysis. No reasoning. Just granted. Meanwhile, when speech rights are involved, those same courts write 20-page analyses full of precedent and legal detail. In one shocking case, a 127-page district court opinion, filled with historical sources and deep constitutional reasoning, was overturned by an 847-word stay. 847 words. To suspend the rights of over 4 million Americans. That's not justice. That's bureaucracy hiding behind a gavel. The social media trap. Some of the laws being kept alive by these flimsy stays go way beyond reason. In New York, gun permit applicants have to turn over their social media accounts, all of them. For the last 3 years. Facebook, Twitter, Instagram, even private messages. Then they must explain why they need a gun, provide character witnesses, and defend their beliefs in personal interviews with state officials. Imagine if you had to do all that just to exercise free speech. It's a system designed not to protect, but to discourage citizens from even trying. The felony trap. In Maryland and Illinois, ordinary citizens followed court rulings saying carry bans were unconstitutional and still got arrested. One man spent 14 hours in jail and $8,500 in legal fees defending a right the court said he already had. States were effectively daring people. Go ahead, exercise your rights. Let's see if you're brave enough to risk prison for it. This isn't law enforcement. It's legal intimidation. The backlog crisis. Right now, more than 47,000 concealed carry applications are frozen nationwide. California, New Jersey, Hawaii. People who paid fees, passed training, and submitted fingerprints, waiting months, even years, because states don't know which law to follow. Translation: they're stalling. And it's costing citizens millions of dollars and their constitutional rights. The leaked emails. Here's where it gets truly explosive. Internal state emails, uncovered in lawsuits, reveal officials openly discussing how to keep enforcing gun laws they knew were unconstitutional. One New Jersey attorney wrote, requesting stays from appellate courts is our best bet to keep the framework in place for at least another 18 months. A California official admitted, we're confident the Ninth Circuit will give us the stay even if the analysis is thin. And a memo from New York outright said the quiet part out loud. Even if we ultimately lose, the deterrent effect of enforcement serves the state's interest. They weren't defending the law. They were weaponizing delay as a policy tool. The Supreme Court steps in. This emergency order is the court's message to every state and every lower judge. The Constitution is not optional. You don't get to ignore rulings, stall justice, or bury rights in paperwork. Not for 18 months. Not for a single day. This case could redefine how every future gun rights lawsuit unfolds, and whether Americans' constitutional protections actually mean something. If you believe people deserve equal justice under the law, no exceptions, then subscribe right now and stay with us as we break down what happens next. Because this story isn't just about guns. It's about whether your rights still matter when the government decides they don't.